4 a.m. Rockville, Maryland. Spiral staircase. A bathroom faucet running for 45 straight minutes while a man tries to splash a high out of his face. That's the image one filing wants you to sit with. Not a stat sheet. Not a press release. A faucet. And here's the part that's been twisting in my chest all week. Stefon Diggs is the one who sued first. He's the plaintiff. He chose this courtroom. He picked up the pen, walked into a federal judge's house in Maryland, and said, "Prove it." 3 months later, Christopher Blake Griffith said, "Okay." Quick thing before I get into this, y'all. If you mess with the way we break these down, the kind where we actually read the paperwork instead of vibing off a headline, hit subscribe, smash the bell, drop a like. That's it. Back to it. So let's set the table fast, because the texture of this case is different from anything Diggs has walked through so far. The case is Diggs versus Griffith, case number 8:25 CV 03767, sitting in the United States District Court for the District of Maryland, filed mid-November 2025 by Stefon's team after an October 1st, 2025 state court complaint alleging libel. Griffith, full name Christopher Blake Griffith, a stylist and entertainment marketing figure who'd been around Stefon's circle, filed his answer and counterclaim on November 21st, 2025. The what is a defamation suit Stefon brought over Griffith's public accusations of drugging and assault. The where is a federal courthouse in Greenbelt. The when that actually matters is May 4th, 2026, the day Griffith dropped a reply brief that reads less like a defense and more like a man with a 30-page receipt collection finally getting to clear his throat. Watch this. Let me get the quote bank up first, because half the conversation online is built on paraphrased telephone, and I'm not interested in that. From Griffith's incident report filed with Montgomery County Police, the language is blunt. Stefon Diggs drugged and sexually assaulted me on May 22nd, 2023, and then 1 week later he conspired to have me killed on May 29th, 2023, to suppress his gay/bisexual secrets from becoming exposed. Okay, that's not a soft accusation. That's a man walking into a sexual assault unit and naming a hit attempt in the same breath. Stefon's side has pushed the opposite read. Per covering the libel filing, Diggs' team accused Griffith of spreading false information for clout and attention, and is seeking damages plus attorney's fees. Fair. That's what plaintiffs in libel suits say. The problem is what comes after the press release. Then there's the courthouse language itself, surfaced through the May 4th reply. Griffith's counsel writes that Diggs is 80 days late on sworn interrogatory answers and has produced roughly 75 pages of documents, none of which originated from Diggs himself. 80 days. Let that breathe. Covering the financial records motion, quotes Griffith's filing demanding to see Diggs' books to test the alleged reputational and endorsement damages. A man suing for lost income has to open the income. And finally, because I want this on the record before we go further, captured the framing Griffith's team has leaned on publicly. Allegations this serious can't be ignored. I don't have a reaction for that one. Sometimes a sentence does its own work. Here's where I had to slow down, because the chronology actually does the talking once you line it up. May 2023, the alleged Rockville night. Days later, the elevator footage. That's not in dispute as an event. Darez Diggs, Stefon's brother. And let me pause there for a second, because half the internet keeps calling him Darius, including most of the talking head videos floating around. His name is Darez. He was sentenced to 2 years of probation in 2024 over that elevator attack on Griffith. Original reports show Darez standing in the elevator while 2 other men kick and punch Griffith inside the lift. So when Stefon's libel suit calls the whole story fiction, there's a probation order in another courtroom that says at least the elevator part wasn't fiction. Keep going. October 1st, 2025, Stefon files state court libel. Mid-November 2025, case removed to federal court. November 21st, 2025, Griffith counters. December 2025, separate, completely different incident. Stefon allegedly assaults his personal chef, Jamila Adams, in Massachusetts, per a police report covered by the Post. February 6th, 2026, a third civil suit drops. Not a Porsche, a Ferrari. A former associate alleges Diggs falsely told people he stole the vehicle after law enforcement concluded third parties did it. That filing also alleged civil conspiracy and an assault tied to the dispute, per the coverage. Actually, hold on, back up. That February 6th date is the part. Days before Super Bowl 60. Stefon's playing for New England. A second defamation pattern surfaces, while the first one is in active discovery. That's not noise. That's a pattern problem. March 12, 2026, the Patriots cut him. $16.8 million in cap savings, per. May 5, 2026, the Massachusetts jury acquits him in the chef trial. Not guilty on both counts. 48 hours later, May 7th, the Maryland docket lights up. May 8th, joint status report. May 15th, Stefon's side files a motion to stay the civil conspiracy counterclaim. Notice what's happening here. When the criminal case, try to pause the civil one. The legal calendar is choreography. 3 things in this filing nobody's slowing down to read properly. Griffith says specific custom chrome hearts pieces, a tiny cross necklace, special order, custom length, ordered 4CB, out of the LA store, were taken off his neck during the May 2023 attack. He then says he watched Stefon wear those exact pieces publicly, photographed alongside one of the men Griffith names in the underlying assault. That's not a vibes accusation. Custom length is a fingerprint. Chrome Hearts log special orders. Either the LA store has paperwork that matches Griffith's claim, or it doesn't. Discovery is going to find out. I had to read the reply brief summary 3 times to make sure I wasn't missing something. Griffith's counsel doesn't just say Stefon is slow. The brief calls his responses facially deficient. Boilerplate objections, vague references to documents not yet produced, promises to supplement. Specifically, Stefon allegedly didn't identify all the devices used for relevant communications, didn't properly identify his own social media posts referencing Griffith, and gave only conclusory answers on the supposed reputational and emotional distress damages. Read that again. The man suing for reputational damage can't articulate the reputational damage. That's not a defense problem. That's a plaintiff problem. 2 names that should have been on the table from day one, including Stefon's longtime assistant, were allegedly held back until opposition briefing. The reply argues witness identification doesn't require a protective order and should have been turned over months earlier. That's not just procedural griping. Late disclosed witnesses are how cases get sanctioned, and the assistant detail matters for a separate reason. In the Massachusetts chef trial, that same assistant never took the stand. Mila Adams testified that there was internal tension because Diggs allegedly had an ongoing relationship with her, per coverage of the trial testimony. Whatever you think about Griffith's claim, the absence of that witness across 2 separate cases starts to feel less like coincidence and more like a strategy. Sorry, I told myself I wouldn't use that word. Strike it. Call it what it is, a pattern. Watch the framing split, because it tells you everything about which outlets are leaning on the press release and which are reading the docket. The NFL-adjacent press, coverage, write-up, leads with the procedural language, discovery delay, motion to compel, financial records, clinical, distant. The reader walks away thinking paperwork dispute. That framing protects Stefon. It makes the story sound like lawyers being lawyers. The Black Entertainment Press, BET, the Jasmine brand, leads with the substance. The report, the elevator video, the jewelry. That framing forces you to look at what Griffith is actually claiming. Different lane, completely different center of gravity. And then there's the loudest counter-narrative, the one I want to deal with head-on, because it's everywhere in the comments. Stefon just won the chef trial, so the rest of this is going to fall apart the same way. I'll steelman it. The acquittal in Massachusetts is real. The jury heard from Mila Adams and came back not guilty on both counts. That's a fact, and it absolutely cuts in Stefon's favor in the court of public opinion. But, and this is the part that just one crowd keeps skipping, that was a criminal case, with a beyond a reasonable doubt standard, decided on the specific facts of a December 2025 night in Dedham. The Maryland matter is civil. Different standard, different burden, different evidence, different plaintiff. And here's the kicker, the plaintiff is Stefon. He carries the burden in his own libel case. He has to prove falsity. He has to prove damages. and right now his own filings suggest he's struggling to do either on a discovery schedule. A win in Massachusetts doesn't make 75 pages turn into 7,500 in Maryland. The shift in this case isn't about who's loud online. It's about who's producing documents and who isn't. The mainstream take is that Stefon is winning. Not guilty in Massachusetts, still a household name, still on the NFL free agent radar in 2026 with multiple landing spots reportedly in play. From the outside, the man's untouchable. Here's the angle I keep landing on, and I'm holding it loose because civil litigation is unpredictable, but the shape of it is too clean to ignore. Stefon's legal strategy is built around being the plaintiff. The libel suit was filed October 1st, 2025. The chef criminal case was already moving through Massachusetts. The Ferrari civil suit hit in February 2026. That's 3 open fronts. By suing Griffith first, Stefon's team turned the loudest accuser into a defendant, which sounds like a power move until you remember that being the plaintiff means you carry the burden. You file the discovery requests. You produce the documents. You prove damages. And the May 4th reply brief is basically Griffith's lawyers saying, "You brought us to this dance, and you're not dancing." That's the read. Stefon's libel suit may have been less about winning and more about controlling the narrative window. Pause the public conversation, freeze the timeline, ride out the chef trial first, then deal with Maryland from a position of momentum. The acquittal happened May 5th. The motion to stay the conspiracy counterclaim was filed May 15th. 10 days. That's not reactive lawyering. That's a calendar. But here's where it gets uncomfortable for Stefon's side, and I want to be careful with how I say this. Every additional motion to delay, every late interrogatory, every protective order skirmish raises the same question Griffith's lawyers are quietly building toward. What is in the discovery that's so painful to produce? Devices, social posts, witness identities, financial records showing actual endorsement loss. A libel plaintiff with a clean case doesn't fight discovery. They live for discovery. Discovery is where you prove the lie hurt you. The opposition will say, he's a high-profile NFL player. Of course his lawyers are protective of his records. Reasonable. He's an all-pro receiver with marketing deals to shield. Also reasonable. He just won a criminal trial. He's earned the benefit of the doubt. Defensible. And yet, the elevator footage is real. Darez's probation order is real. The pattern of 2 separate defamation countersuits against him in 18 months is real. The chef testimony about an internal harem dynamic, real or not, is on the trial record. None of those points individually proves the Griffith claim. All of them collectively make this not a clean libel case to win. It's the difference between innocent and suable. The first is a verdict. The second is a problem. What sits with me, real talk, is that the Griffith case has the texture of a fight Stefon's side didn't fully wargame. They expected an influencer with a Twitter receipt. They got a man with a Montgomery County incident report, a brother on probation paper trail, custom-ordered jewelry records, and lawyers who clearly didn't come to play. The path most likely to play out, by my read. Watch how the Maryland court handles the discovery dispute through the summer. If the judge orders Stefon to produce financials and devices on a hard deadline, the leverage shifts overnight. A protective order isn't the same as a shield, and Maryland federal judges aren't known for letting plaintiffs slow-walk their own cases. Expect a serious motion to compel ruling before fall. The flip-the-table scenario. Don't be shocked if Stefon's team quietly explores withdrawing the libel suit before the financials get turned over. Voluntary dismissal sounds like a retreat, but it's also how high-profile plaintiffs cut losses when discovery starts threatening more than it protects. Watch for that filing. If it comes, the counterclaim survives, but the offensive war is over. 5 years out. And this is where it gets bigger than one case. The aftershock is going to hit how NFL teams handle off-field civil exposure during free agency cycles. The Patriots released Stefon in March with a $16.8 million cap clearance the same offseason multiple civil suits were active. Once teams start writing morality clauses around civil litigation, not just criminal, the entire veteran market changes. Diggs didn't cause that shift by himself, but his docket is the case study future GMs will pull up. One specific failure prediction for Stefon's current legal posture. By the end of Q3 2026, expect at least one of the 3 active civil matters to settle quietly, with a non-disclosure attached. The math doesn't favor fighting all 3 to verdict. Cases get pruned. The Ferrari one is the most likely to fold first. It's the least emotionally charged, the easiest to make disappear with a number. And the reason the favored side, meaning Griffith here, is positioned to come out of this with at least a partial win isn't because his claim is unassailable. It's because he chose the right defense, and he chose it early. Truth as an affirmative defense to defamation isn't a vibes argument. It's a documents argument. He's got Montgomery County paperwork, an elevator conviction in his brother's name, a chain of custody around the jewelry, and a financial records motion that puts Stefon's books on the table. You don't beat that with a stay motion. You beat it with production. And production is the one thing Stefon's side has been allergic to since November. The last thought I want to leave you with, because the Cardi B layer floating around the discourse keeps pulling focus away, is this. The Maryland case isn't about a celebrity relationship. It isn't about a Super Bowl. It isn't about the chef trial. It's about whether a libel plaintiff can survive his own discovery obligations. That's a much smaller, much colder question. And those are usually the ones that decide everything. Y'all stayed for the long read, which means you actually care about this story, not just the headline. Hit subscribe and ring the bell so the next breakdown lands in your feed the second a new docket entry drops. Because believe me, this case is about to start moving fast. Drop your honest take in the comments. I want to hear who you trust and why. See you in the next one.